This video discusses the powers of a guardian to sell the property of a minor. The sections of the Guardians and Wards Act 1890, namely sections 27, 29, 30, and 31, interconnect and operate together to regulate the powers and duties of a guardian of the property of a ward appointed or declared by the court. Here's how these sections work together. Section 27, Duties of Guardian of Property. This section establishes the general duty of a guardian of the property of a ward. It requires the guardian to handle the ward's property as carefully as a person of ordinary prudence would handle their own property. The guardian is allowed to take reasonable and proper actions for the realization, protection, or benefit of the ward's property. Section 29, Limitation of Powers of Guardian of Property. This section imposes limitations on the powers of a guardian appointed or declared by the court. Without prior permission from the court, the guardian cannot mortgage, charge, sell, gift, exchange, or otherwise transfer any part of the immovable property of the ward. Additionally, the guardian cannot lease any part of the property for a term exceeding 5 years, or for a term extending more than 1 year beyond the date when the ward will cease to be a minor. Section 30, Voidability of Transfers made in contravention. Section 30 states that any disposal of immovable property by a guardian in contravention of Section 28, or Section 29 is voidable at the instance of any other person affected by such a transfer. In other words, if the guardian exceeds their authority as per Section 29, the transfer can be challenged by anyone affected by it. Section 31, Practice with respect to permitting transfers under Section 29. This section provides guidelines for the court when granting permission to a guardian to perform acts mentioned in Section 29. It emphasizes that permission should only be granted in cases of necessity or when it is clearly advantageous to the ward. The court must specify the necessity or advantage, describe the property involved, and set any necessary conditions. These conditions may include requiring court sanction for a sale, conducting public auctions for sales, specifying lease terms, or directing the handling of proceeds. Additionally, before granting permission, the court may notify and hear from relatives or friends of the ward who have an interest in the matter. This brings us to a common question. Can all adult shareholders in jointly owned inheritance property sell, alienate their own shares independently without notifying the guardian court? Yes, in the case of 2003 CLC 857, it was established that major co-sharers should not be restricted from alienating or transferring their own share. Therefore, the sale made by the major shareholder to the extent of their own share was considered legal, and there was no requirement for them to obtain permission from the Court of Wards for such an action.